You get hit with a rubber bullet at a protest and suddenly you are starring in your own legal drama nobody auditioned you for. Welcome to the wild world of crowd control injury claims, where the plot twists come faster than a soap opera. Here's the thing nobody tells you. When police deploy tear gas or batons during a protest, the question of who pays for your busted collarbone gets complicated fast, because there are usually multiple parties who could be responsible. You might think you just sue the officer who swung the baton at you, but most of the time you're actually dealing with something called qualified immunity, which is basically a legal force field that protects government workers unless they clearly violated a right that was already spelled out in a previous case. Qualified immunity sounds like a video game power-up, and honestly, it kind of works like one. It means your lawyer has to hunt down a nearly identical past case to prove the officer should have known better, which is like trying to win an argument by only quoting movies that already exist. Now let us talk about who else might be on the hook. Cities, police departments, and even private security contractors hired for the event can sometimes be named in these lawsuits, depending on who actually authorized the tactics used. This is where something called Monell liability comes in, named after a 1978 Supreme Court case. It means you cannot just sue a city because one officer messed up. You have to show the city had a pattern, policy, or training failure that caused the harm. Think of it like blaming the whole pizza shop instead of just the one guy who dropped your pepperoni. You need proof this is not a one-time slip-up, but a habit baked into how they do business. Evidence is everything in these cases, and in 2025 that mostly means video. Bystander phone footage, body cameras, drone shots, and even doorbell cameras have become the backbone of proving what actually happened before the lawyers even show up. Timing matters too, and this is where people mess up constantly. Most states give you somewhere between 1 and 3 years to file, but government claims often require a formal notice within as little as 6 months, so waiting around is basically legal self-sabotage. There is also the tricky question of comparative fault. If you were, say, throwing water bottles before things escalated, the other side will absolutely use that to argue you share blame, which can shrink your compensation depending on your state's rules. Damages in these cases usually cover medical bills, lost wages, and something called pain and suffering, which is the law's fancy way of saying your trauma has a price tag. Emotional distress claims are also common, especially when someone develops anxiety or post-traumatic stress after a violent crowd event. Here's a plot twist most people do not expect. Journalists and even legal observers wearing clearly marked vests have successfully sued after being targeted, because courts have started recognizing that press freedom claims add another constitutional layer on top of basic injury law. There is also a growing use of expert witnesses, like use of force specialists, who testify on whether the police response was proportional to the actual threat. Think of them as referees who get paid to say whether the foul was really a foul. Doubt creeps in a lot here because these cases can take years and settlements are not guaranteed. But preparation, meaning documenting everything immediately, getting medical records fast, and finding witnesses before memories fade, is what actually separates a strong case from a shrug emoji in court. If any of this sounds like something you or someone you know might be dealing with, do you want to learn more about how we help with cases like this? Check out our links in the description.